All right. So we're going to get started this afternoon. Thank you all for joining us and taking advantage of this training session on child welfare daysheet coding. My name is Evan Friedel. I'm the Title 4E coordinator for the state of North Carolina, and I'm joined today by Philip Armfield. He will be assisting me with technical issues. So anything that goes right is all because of him. Anything that doesn't go right is all because I clicked the wrong button. But together we're going to try and give you a little bit of information and knowledge about child welfare daysheet coding. Ultimately, it's about how we connect the dots and want to have it make sense for y'all, like it says on the title page. And really what this is ultimately going to be about is helping you guys through a critical and necessary and sometimes frustrating part of your day. But hopefully before the presentation is over, you'll have learned a little bit about day sheets, about coding, and how to ultimately maximize the results for the effort you're putting in. And that's really what this is about. And the theme you'll hear me repeat many times today is giving yourselves credit for the work you're doing. Y'all are working incredibly hard, and we want to make sure that you're getting credit for that good and challenging work. So some daysheet basics. What are daysheets? They're essentially a bill to the state for the services you provide. When you go out every day and provide services to the children and families you work with, as well as to the county for a whole, you need to bill for those services. You don't provide those services for free. You're not a volunteer. You are a paid member of your child welfare team. And in order to get those services paid for, you have to submit a bill. And daysheet funding, the reimbursement that is received by the county from daysheet input, helps to pay worker salaries as well as pay for the equipment you use, the power, keeping the lights on, the cars, the gas, every little bit from the cell phone you carry all the way up to the building you work in and everything in between. That is helped paid for by the funding brought down by daysheets. A way to think about it from an analogy perspective is it's similar to a plumber fixing a leak. If you come home from work today and you discover that there's a leak in your kitchen and you go ahead and call the plumber's going to come out. Plumber's going to go ahead and look at the issue and hopefully fix it. And when the plumber fixes it, they're going to give you a bill for those services and you're going to pay the plumber and everybody's happy. You have a fixed sink and the plumber is paid for the time and effort they put out in fixing that sink. That's ultimately, when you really break it down to its most basic level, what daysheets are. They are an invoice for the services that you're providing. Now, to look at it from a flowchart perspective, this is the way that the process is supposed to go. A social worker is going to enter activities on a daysheet. And that can be either on a physical piece of paper in terms of the 4263, which we'll look at in a moment, or it can be on an electronic daysheet system. That would be via the programs like Information Inc. some counties use. Some counties have developed their own electronic daysheet process, but that's fine. Either way, the worker enters their time. A supervisor is going to review and approve that time, making sure that it's appropriate. The county is going to submit that daysheet data to the state via upload, usually electronic upload. DSS is going to determine if money is available based on the codes entered. Now, we're going to talk a little bit more about that a little further on in the presentation. But basically, the coding that you use tells the state which pot of money or bank account almost to pull that money from. And we'll talk more about that sample and that idea in a second. But if indeed there's money available and it's been approved by the state, then those monies are sent back to the county to help reimburse for the expenses and the effort that you've put out there. So we're going to go ahead and pull up a copy of the day sheet now to show it to you. This is the 4263. And the 4263, for those of you who've been around as long as I have, although it's not green on this particular screen in front of you right now, it is actually a green sheet. So if you hear some people talk about day sheets and call them green sheets, that's what they were back in the day. And if you still have these forms, they are green, that are provided by the state. But ultimately, you can see what it's tracking is for each worker, it's talking about the county's provider number, the month, the year, the worker's ID, the county provider name, the worker name, and then the client. You put your client's name, the day, the service code. We're going to talk about that in a minute. The client's ID, which would either be their SIS code or their CNDS number if they're an NC Fast, the number of minutes that you used, and then the program code. And that is critical because it's ultimately the combination of the service code and the program code that provides the direction for the reimbursement. And then there's also a column here for comments. That's a place where you can notate something specific about the activity if it's necessary. Otherwise, you're going to document in the actual case record. You'll also notice down here that there's a signature. This signature certifies that it's an accurate account of the time and services provided above. This is critical. The day sheet has to be signed by the worker, whether that's an electronic signature if you are utilizing an electronic system, or a wet signature or a physical signature if you're using a paper-based system. But the worker is the only one who can enter that data, and they must sign certifying that they've done so. All right, so we'll go ahead and move on to our next slide and take this one off the screen. And so when we talk about the basics, as I said when looking at the green sheet, the 4263, it's a combination of two items. The service code. The service code tells us what you did. For example, 109 is time spent on a permanency planning case. 215 might be for in-home services, etc. The program code, which is the second half of that day sheet coding, tells us which account to pull the money from. Remember, I said each program code focuses on a specific account. If you think about them as bank accounts, in general, each account has a set amount in it at the beginning of every budget year. There are a few exceptions to that, and we'll talk about those as we go through. But in general, there is a set amount in every account. And as long as there is money in that account, you're able to pull down money. However, if the money in the account is spent for the year, is completely spent, no more money will come to the county for the time sent to that code. Think about that like a checking account. You can write checks all day long. However, the bank is only going to put them through and pay them if there's money in your account to go ahead and back up the check you've written. The day sheet coding is very similar. If the pot of money, the account that you're coding to, does not have any money in it, any funding left, then the state will not provide any reimbursement for that coding combination. So we'll talk more as we go forward about the different pots, but this is the basics that I hope that you'll remember, is that every day sheet code is a combination of two things, a service and a program code. Now, day sheets are also an audit trail for services. There are many different audits that look at day sheets. There are state audits through the child fiscal monitors, child welfare fiscal monitors. There are also audits that are done at a county level. The single county audits will come in and look at your processes, as well as federal audits can look at day sheets. We've had a few of those over the years as well. Now, everything recorded on a day sheet must be documented in your agency records. Remember, as I said at the top, part of this is about connecting the dots. Well, day sheets have to connect a dot to your narrative. So if you've provided an activity that you're documenting on your day sheet, we should be able to go in and look in your narrative in the case file and find some connection to that activity, so we can see that you were doing what it is you said you did on the day sheet. So again, you think about it from a one-to-one relationship. If there's an entry on the day sheet, there should be something reflected in the narrative, and vice versa. If you've given yourself credit for something in your narrative, hopefully you're giving yourself credit for it in your billing on your day sheet as well. And as I mentioned, when we looked at the actual form, the worker has to complete their own day sheets. They must do so. It cannot be completed for the worker by anyone else. Not a supervisor, not a manager, not a director, not an admin assistant. It must be completed and signed for by the worker. Now, when should they be completed? Now, here's a hint. It's in the name, day sheets. We would like to have day sheets completed contemporaneously, and that's your SAT word for the day. Contemporaneously is at the same time. In a perfect world, which I recognize we don't live in, but in a perfect world, we would hope that workers would be filling out their day sheets as they go. Now, if you were using the old green sheets, that's one benefit you have. The sheet is physically with you, and when you go from activity to activity as you go along, you could be documenting the person you've worked with, the amount of time, and even if you didn't know the program code until you got back home, because that's based on eligibility, which we'll talk about as we talk about the specific codes, equally, it would give you the opportunity to keep track on a running basis. However, we know that we don't live in a perfect world. We also know that with the prevalence of documented systems, day sheet systems like Information Inc. and other county developed systems, it's harder for people to be able to enter day sheet coding contemporaneously. They may have to wait till they get back to the office or back to their computer. So what we recommend is if you're not going to do them daily, at a bare minimum, submit them weekly because it gives you the opportunity to make sure you're still fairly certain of what you did. Now, even if you don't carry your day sheet system with you, if you can't do it remotely, you can certainly keep notes. So when you do sit down to do your day sheets, you are able to have an accurate picture of what you've done. Remember, it is designed to be an accurate bill of your service, not an estimation. We don't want to see on a day sheet for a week that every day during the week you saw 6 clients for 80 minutes a day to make up your 480 minutes on your day sheet. I don't believe that anybody is that good at their time that they can make their visits all average out to 80 minutes. That's a pretty good key to an auditor, that the worker is making some summaries about their visits or guesses. It's critical to be as accurate as possible. To that end, you don't have to be down to the single minute. You can round into blocks of 5 minutes, 15 minutes. That's up to each individual county to set up in terms of, do they have a minimal entry limit? I've not seen any counties go lower than 5-minute blocks, but in any case, you should strive to be as accurate as possible. The other reason it's critical to submit weekly is that day sheets lock on the 5th day of the next month. For example, April's day sheets, so day sheets for any and all activities you did in April, lock and do not allow any edits after the 5th of May. That means that if you've waited till the end of the month to do your entire day sheet entry process, and then let's say an error is discovered, well, if you're out of the office, either you're on vacation or you've more than likely been called out to an urgent need with a family, and your business office or your supervisor is looking for you to correct that error, and you're not available, that error will go unfixed and ultimately mean that the county will be unable to claim that time, essentially meaning you have worked for free. And while, again, we love the work we do, very few of us are able to do this work for free long term, not to mention that the county isn't able to keep the doors open and the lights on if we're not able to draw down that reimbursement. So it is critical that we do these regularly and as accurately as possible. Now, some general thoughts about day sheets and guidance. Anytime that the worker is scheduled to work, and all overtime has to be accounted for. If your workday is slated to end at 5 o'clock, but you are on an urgent call or working until 6 or 7, that time should be accounted for in your day sheet. It needs to include all direct service time, case management activities, administrative time like paperwork, comp time, and leave taken. All of the time related to your day should be accounted for on a day sheet. As I mentioned earlier, it should not be an estimate. It needs to be an accurate representation of your work. And the only way to ensure success, and you will hear this theme again today, I promise you, the only way to ensure success long term is that there is ongoing communication between the services and social work team along with the business office and your fiscal team. Those two sides of the house are critical. The services team, the social workers, you know what you did. You know what you're doing with these families. You are accurately recording what's going on and what you're doing out there in the field. And the business or fiscal team, they're the ones who know and understand what pots of money are available, where there is still money left to be able to code and draw down. And while the fiscal office can't tell you what to code, and that's critical, because the easiest way to fail an audit is when an auditor asks you, why did you code this particular combination? If you answer, because they told me to, I can guarantee you that will be a short but painful audit for you, because they will fail that particular entry and you will move into a corrective action. However, the business office is allowed and encouraged to tell you what pots are available. So when you determine eligibility for the child or family you're serving, and we'll talk about those eligibility requirements a little further on, but when you look at eligibility, a child may be eligible for more than one pot. And if the business office is saying this particular pot has more money than the other, or the other pot is empty, so if a child is eligible, please use pot A, then that is not only allowable, that is encouraged and highly welcome, because it again means you're going to maximize the return on the hard work that you're doing out there with those children and families. So now we're going to kind of jump into this, and we're going to talk about the core child welfare service codes. And what I mean when I talk about core child welfare codes is that there are about 5 or 6 different service codes that can account for anywhere from 80 to 90% of the child welfare work we do, depending on the specific issues in your county and the situations that your children and families are dealing with. But our goal here is not to help you understand every possible permutation of coding. There are literally thousands of combinations when you put together all the service and program codes that are available in child welfare. There just isn't enough time for us to be able to do that. However, what we're going to do, and our goal is to help you have a working knowledge of the basics, of the happy path, if you will, for child welfare. So if you understand these by the end of the workshop and with the resources that we'll give you, that'll give you an excellent foundation to build from, and then recognize those scenarios for that other 15 to 20% of cases that might not fall into the core. Then you'll know to be able to ask more specific questions and look at some of those resources to get those coding combinations if they don't fit these basics. So with that being said, one of the most important things that I can offer to you going forward is the KISS model and the KISS mentality. Keep it simple, social worker. As I mentioned, there are thousands of possible combinations between service and program codes. What we want you to do is keep it as simple as possible. Think about what you're doing, what is the child eligible for, and then ultimately, is there money available to code there? If you can answer those 3 questions, what you're doing, what is the child eligible for, and is there money? If you can do those 3 consistently, you are going to be well on your way to maximizing your funding. And that's our goal for you. Again, credit for the work you're doing. So the first service code we're going to talk about is at the beginning, intake 211. protective services for children at intake. This service code includes any and all activities that are associated with the intake process. That includes receiving the report, whether that's in person or by phone, the evaluation of that report, including the entire process of going through and reviewing it, consultation with a supervisor or other members of your team, assignment of the case, notification to the people who are picking up that case once it's been assigned, as well as any and all related paperwork. That includes writing up the intake. It may include other paperwork, generating the case, etc. So all of that's going to fall under 211. The program codes that can be used with 211, and remember this is the second half of the equation, are 9, 0, R, 23, and CPS. We'll talk a little bit more about those as we go forward. Eligibility is not required for any of the program codes with 211. Now this is important because you may remember me saying just a few slides ago that in general we have to evaluate what a child is eligible for. And there are other areas of child welfare where eligibility is hypercritical. There are very specific requirements as to when we can and cannot use a specific pot of money. This is, however, not the case in intake, which makes it an excellent opportunity for us to utilize and spend in areas we need to because the eligibility isn't going to be a factor for us. Now, we do recommend that if a county has money available in the 9 pot or MOE, maintenance of effort, it is suggested that the county spend this first in 211. This is the easiest way to spend down that money. This is a pot of money, MOE or 9, that is required to be spent down by the end of the fiscal year. If you don't spend that money down, it has other ramifications further down the fiscal path. We're not going to go into those in too much detail now, but it's easy enough and enough to understand that we have to spend all of the allocation in our 9 pot. Therefore, we want to make sure that wherever possible, we're using it. And in this case, since there are no eligibility requirements for 9 when it's paired with 211, this can be an excellent place to utilize and spend down that pot of money. However, again, it must be in consultation with your fiscal staff. And remember, this is a recommendation or a suggestion. It is not a requirement. Counties must make that choice for themselves. Now, the other thing that's important to know about 211, which is different than a number of the other service areas, is that it doesn't require any child-specific documentation on the day sheets or in the record. And if you think about intake, we may not know much child-specific information. We may get a report that says there is a 4-year-old who is unsupervised out in the park or walking down the street, and that's all the reporter knows about them. Well, it's kind of hard to put child-specific information in the record at that point for an intake if all we know is that there's a blonde-haired child wandering down the street or sitting in the park. Well, while that would be an urgent need and certainly we'd want to respond to that, and later on we may gather information about this child which would be critical to document in later stages of the case, in the intake portion and on the day sheet, we don't have to know that child's information. So you may document on the day sheet or in your day sheet electronic system just an intake name if you have it, or it can be enough, and this is one of the only areas that you can do block day sheet coding, where if you have an intake worker that has done nothing but intake all day, if that's what they're assigned to, that would be an area where they could theoretically code 211 with whatever program code for all 480 minutes or however many minutes they worked on intake during that day. It is not required to break it up by child. 211 is the only area that we have that allowance for grouping. The next area following down the path of services is going to be 210 or assessments. The official title is Protective Services for Children, CPS assessments, and this includes all of the elements of the CPS assessment process, all the way from initiation through case decision, as well as the paperwork and travel that are associated with the work on a 210 or assessment case. The program codes allowed to be used are R0, 9, 23, CPS, and CRF. And again, all of those are accepted codes that can be used in the program code section of a day sheet or in an electronic system. If 9 is used, all the eligibility criteria has to be met and documented on a verification form in the case record. If a child is undocumented, so if you have a child who is undocumented that you are serving in 210, you can only use R or 0. The reason for that is because of the undocumented status and requirements of different funding. Remember, we mentioned eligibility earlier. Well, for an undocumented child in the 210 service area, the only codes that they can be used for are R and 0. You may not use any of the other service codes. Now, we're going to talk more about eligibility criteria in just a moment, especially as it relates to 9. But first, we're going to talk about 210R and 210-0. Okay, because as I mentioned it earlier about undocumented children. First of all, one of the most important things to know is that this is federal funding. It comes through an allocation through the federal government. Eligibility in 210 is already established by default and verification forms are not needed. This is based on the definition of the emergency nature of the assessment, the fact that the CPS assessment process is one that's considered to be an emergency service. There is a critical need that's been defined based on our statutes, and the urgent and critical emergent nature of that need overrides the eligibility. Your services and fiscal staff, social workers and business office should be communicating regularly to determine which program to code to, R or 0. Which pot has money available to it. Now, this next bullet is very important to know. Services can only be coded to R or 0 for 364 days per episode. And it doesn't matter. If you code to 1, it starts the clock on both. And when we talk about episodes, that is for continual services. It is not just for a service code. So for example, and we'll talk about this in the other service codes, but if you start coding on R or 0 on January 1st, then you have only until December 31st, rather, to code R for that episode. It doesn't matter if 210 ends in 30 days, and then you move to 215, and then you move to 109. The moving to a new service area doesn't restart your clock. The only way that you restart your clock for that 364 days is if you have separated yourself and the family is separated from our services completely in child welfare. If we have separated and closed out all services and then a new report comes in, then that clock is allowed to restart. Otherwise, you are unable to do so. And as I mentioned earlier, if the child is undocumented in 210, you can only use R or 0. You may not use any of the other program codes. The next code that we're going to discuss is 210-9. 9, or as MOE, as I mentioned earlier, maintenance of effort. This is also a federal funding. It is also capped, which means there's a specific amount that's allocated during the year, and when we finish that funding, the pot is empty. And again, like writing a check to an account that has no money in it, there'll be no return. Some of the requirements that are necessary in order to be eligible for 210-9 is that the family's income must be at or below 200% of the federal poverty level. The child has to be living with a specified relative. We'll talk about those in a moment if you're not familiar with them. You must document that the goal is to provide assistance so that the child may be cared for in their own homes or in the homes of the relative. The child must be a U.S. citizen or have qualified alien status that you can document. Either of those statuses must be documented and evidence has to be present in your record. And the eligibility has to be documented in the record. An auditor, if you have coded 9 to this service area, has to be able to find documentation of that eligibility. To that end, we have a specific MOE eligibility form, which I'm going to bring up here now. And this MOE form, which you'll now see in front of you, has some very simple questions. It has the date the eligibility is determined, the social worker is going to sign. It asks, is the family's income at or below the 200% of the federal poverty level? What's the source of that knowledge? And it can be because the family receives work first, Medicaid, food stamps. Those are documentations that they're below the 200% of the federal poverty level. It can be just a regular reference and lookup with your income maintenance team, but you do want to document how you got that information. You want to identify the specified relative with whom the child is living and the relationship. Parents are definitively a specified relative, so that's the easiest way, but there can be other specified relatives as well. Third, we want to document how does the provision of this service meet the TANF purpose. And if you'll see down here below that, it talks about that the purpose related to child welfare is to provide assistance to income-eligible families so children can be cared for in their own homes or homes of a relative. That's our general purpose for every family that we're serving in child welfare if we're using 9. And you can imagine if you're in foster care, there might be some situations where this doesn't apply, because if we're not trying to care for the child in their own home any longer or the home of a relative, then this would not be an appropriate use of that funding. And is the child a U.S. citizen or a qualified alien? And please check one. It's a very simple form, and it makes life much easier for yourself and an auditor if you have it just right there in the record with your documentation. You'll see on page 2 of this form there are redeterminations. Redeterminations have to be documented annually. Now in child welfare, it's not always as likely that we have used MOE over a year. It is possible, especially if the child's in foster care under certain circumstances. And so if indeed you are using this code for more than a year, you would just need to document the redetermination and how these were all met for each of the questions. There's a line, date of the redetermination, and a signature, and you're done. It's simple. It's not too challenging. But the consequences can be critical if you don't have these in your record and the case is pulled for audit. We don't want to have a county deal with payback situations, especially when the ability to meet that need is fairly simple. So we'll move back into our presentation now. And the next code we're going to talk about is 21023. This is state funding. It's a capped pot. Now, it's provided by the state legislature. It's provided to some counties. Not every county has this funding, but it was provided by some counties based on workload and case activities studies several years back, and it helps pay for the state share of CPS staff expansions. Now, if you are going to go ahead and utilize this fund, the family's income must be at or below 200% of the federal poverty level. The child must be living with a specified relative, and the eligibility of such must be documented in the record. Now, you'll notice it's fairly similar to the MOE documentation and requirements. The only difference is that you don't have to have the requirement of citizenship. The state funding did not make that same requirement, unlike federal funding. So you could document this in the record any number of ways. There isn't a specific documentation form, unlike the MOE form. So you could document it in your ongoing narrative. You could actually use the MOE form and just write in that you're doing this for eligibility for the CPS or 23 funding code. Or you could just, if you've documented it under 9 already, if you've done MOE, then you've met your requirement for this, and you can just reference it if needed. But if you haven't done an MOE verification and you are using 23, then you must go ahead and make sure that you've entered a documentation of these eligibilities having been met. The next code we're going to talk about is 210 CPS. CPS is also state funding capped. It is a set pot of money, again, provided by the state legislature for counties. There is no financial eligibility documentation required. This is sort of a freebie in that any child that's being served by 210 can be coded to this code. However, there's always a however. You must be talking with your business office and the fiscal team to determine if these funds are available for day sheet use, because this funding that's provided by the legislature can also be utilized behind the scenes to pay for other things, not just for day sheet service time. So it's important that you're not coding this to day sheets if your business office is using it to pay for other appropriate eligible expenses, because what you're going to end up doing is essentially double billing and getting us back to that issue where you're writing a check to an account where there's no money available. So ongoing communication is a must. But if your business office says you have these funds and they're available for day sheets, then this is an absolutely useful code to be able to take advantage of for children and families in this service area. The next code is 210 CRF. This is also state funding. It is also capped. And it also, similar to 23, was provided to counties following legislative action to reduce in the reduction of caseload sizes. Now, unlike 23, there's no financial eligibility documentation required, but like CPS, it's critical that you discuss with your business office if these funds are available for day sheet use or if they're being spent behind the scenes. Like CPS, this is a fund that can be used in a couple of different ways. And if your business office is utilizing this to meet other needs that are helping you serve your families, it's important to know so you don't try and double dip or bill into a pot that's already been spent. So again, that theme of ongoing and critical communication between the business office and the social work side of the house is of the utmost importance in order to be successful. Now, I mentioned that we would be talking about specified relatives. You've already seen a few codes that do require connection to specified relatives, and as we move forward, you'll see even more. So this is a good place to just quickly go over it. A specified relative for the purposes of day sheets is any relation by blood, adoption, or marriage. Now, this is important, even if that marriage has been dissolved by death or divorce. What that means is if Uncle John, who is a blood relative, marries Jane, she becomes Aunt Jane. So she's now a specified relative. Now, even if John and Jane get divorced or unfortunately John dies, Jane is still going to be considered a specified relative for these purposes. The death or divorce does not terminate that relationship for these particular uses. Now, it's important to understand that exception because that's not always the case. As we know, legally, a death or divorce can sever certain relationships, and we have to make certain accommodations based on those. However, in the terms of day sheets, that is not the case. The death or divorce does not separate the relationship for the specified relative connection. And it's up to the 5th degree of kinship up through the child. So that can include a parent, grandparent, sibling, great-grandparent, uncles, aunts, nephews, nieces, all the way up through great-great-great-grandparent or a first cousin once removed. If you'd like to know what a first cousin wants removed, please feel free to reach out to me outside of the presentation, and I'll be happy to have that conversation with you. It also has the kind of words to a Muppet song, I'm My Own Grandpa, and I can provide a link to you on that on YouTube if you feel free to reach out to me as well. However, it does also include any relationship above preceded by step or half. So if they are a step grandparent, half grandparent, I'm not as familiar with that term, but half sibling is probably more common, that still counts for the purposes of specified relatives. So now we're moving into our next service area. This is 215 or in-home services. Again, the 215 service code includes all the elements of the in-home services case. The case management activities, paperwork, and travel are related to this service code. The program codes that are allowed are ZR0, 9, 23, IHE, CPS, N, and X. And so you'll notice there are some new ones in there, and we'll talk about those as we go forward. If your child has been determined to be a candidate for foster care, and we're going to talk about what that means in a second, you must use 4E. I want to repeat that because it is critical. If a child has been determined to be a candidate for foster care, it is the code that must be used. So Z trumps all other codes regardless of the fact that the child may be eligible for another code. If the child is not eligible for Z or not found to be a candidate for foster care, or until the time that you've met all of those requirements, you can use one of the other codes. And again, we'll talk about what that means in just a second. However, another major difference between this and the 210 area, if the child that you're serving is undocumented, not a citizen, not a qualified alien, you must use program code N as in Nancy, N as in no, or no other codes allowed. So that is important to keep in front of you. If the child is not a qualified alien, not a citizen, then they may only be coded to N. However, if the child has documentation and is a citizen or a qualified alien, then we can move into some of the other program codes. The first one we're going to talk about is Z, or the 4E code. Now, Z is federal funding, but you'll notice for the first time we have a fund that's uncapped. What that means is just like it sounds. There's no limit to the funding. While there may be a quote-unquote allocation of 4E, the reality is the more that you code, the more that you will pull down. It is an unending pot of money. So if you code hundreds of thousands of minutes to Z, you're going to get reimbursed for hundreds of thousands of minutes. So it is important to make sure that we are doing our determinations correctly, because obviously this is one of the most beneficial pots of money for us in terms of return of the investment of the work that we're doing out there. Now, there are several requirements that must be in place before you are able to code 4E or code Z. The first is the case finding from the 210 case must be substantiated or in need of services. Now, you may be laughing to yourself a little bit saying, well, of course, that's a given. We can't move a case into 215 without a finding of substantiation or in need of services, depending on what track it's in. However, unfortunately, we've discovered during some of our audits where there have been cases moved into 215 with a case finding other than substantiation or need of services. A lot of time it seems to be under services recommended. Now, while that may be due to a typo when the case was keyed or due to a misunderstanding of the process, doesn't matter. It will fail an audit. So you must have a substantiation or an in need of services and code those correctly into the system. The second thing is that when you're completing the 5010 in terms of your case closure, which is the CPS documentation form, you have to answer the 4 questions that are in section 12 along with a rationale for the answers. Some people think of this as the case summary part of the 5010, but ultimately these 4 questions address the issues of maltreatment and the risk going forward. So we need to document the answers to those as well as a full rationale for all 4 answers. We must further document that the child's at an imminent risk of removal and or a candidate for foster care, and this is accomplished on page 10 of the In-Home Family Services Agreement. That's one place where it's easily documented, but equally you should be documenting this in your case narrative, that we should be discussing the fact that this child is at risk, and absent the services that we are providing to this family, whether it's through us directly as DSS or the agencies that we're partnering with in the community for and with this family, that without those services being provided and successfully achieved, that this child would be filed for foster care. We would file a petition. Finally, and most important, we must create a service plan with the family, not for the family. Okay, and I think most of us who have been around, again, long enough can remember days where we were either told officially or unofficially, it's time for a case plan. We're going to write that up at the agency, take it out to the family, and yes, we'll discuss it with them, but essentially we're just presenting it to them saying, here's what you need to do and we need you to sign it. That's not acceptable from a 4E perspective. Part of what 4E funding is about, it's not just a funding source. It's about protections to a child and a family in terms of legal protections to the family for their rights, their constitutionally provided rights. And so one of the ways that we provide protection to the family its rights is by ensuring that we're developing a program with them, developing this plan with them, and in conjunction with their desires and goals based on the issues that we've identified. So the identification of the issues is not so much in question as much as the plan that they are going to work with you and with the community agencies to help achieve the goals that you all have set. So when you develop that plan with the family, and then have them sign, that signature is acknowledging that they were involved with the creation of the service plan with you. And once you've met that requirement, and usually that is going to be the last requirement that needs to be met, because the others will generally come a little sooner in the process, but once you've met all 4 of those requirements, 4E can be coded. Now, you can also go back to the first day of the month in which you met the requirements in Code 4E. So what that means, by example, is if the child came into in-home services on the 2nd day of the month, let's say the case decision was made from the 210 assessment on the 2nd of April, and on the 29th of April, you have completed everything else. On that date, you've already answered all the questions on the 5010 as part of the case summary closing paperwork. You've filled out the initial part of the family services agreement and documented in the narrative as well as on there about the imminent risk status, and the family has met with you. You've had your CFT, and the family signed your agreement. You've completed that on the 29th. Well, you are able to go back and claim 4E for the entire month. And since it's before May 5th and the day sheets haven't locked, you could, in that scenario, go back and adjust your day sheets to claim 4E for the child for the entire month. Now, you may not claim it until you're done. You cannot be anticipatory about this and assume that you are going to have a CFT on the 29th and start coding from the 1st onward, because if you don't have that CFT and don't have that case plan completed, then you will be in error. And that error would be subject to a payback if caught in an audit. So you would code something other than 4E throughout the month, and if at the end of the month you determine you've met all these requirements, you can go back and adjust your day sheets, as long as it's done before the 5th of the following month. So I'll pause for a second and let that all digest as we move on to the next service code. Now, 215 R and 0. Now you'll remember R and 0 from before. These are the same R's and zeros that we talked about in 210. It's federal funding. It's capped. Again, we have to have a finding of substantiation or in need of services. The family has to have an income at or below 200% of the federal poverty level. The child has to be living with or have lived with a specified relative within the last 6 months prior to this episode. Okay, remember, going back to the specified relative definition. The child must be a U.S. citizen or a qualified alien, and the verification form must be in the record, and that's the TEA verification form. Now, before we look at that, just the last bullet there is important, and you remember it from the 210 slide. RN0 can only be used for a total of 364 days per episode. Now, again, this is additive, so we have to add in all the time that was spent since the first time you coded 210 R0 and going forward. It's not a total of how many days you coded it. Again, you have to think about it from a calendar perspective. If the first day you coded R for that episode was January 1st, the clock is ticking. Even if you move to something else after January 1st and haven't coded anything else, if this case moves into 215 on March 1st, you're already 2 months of those 364 days down, even if you didn't code it again from January 1st. So the clock is a running clock. Now, the verification, as I mentioned, is critical. So we're going to look here at a moment for the TEA eligibility worksheet. This form, which you'll see here on the slide in front of you, is also fairly simple. It asks for the child's name, the case number, the child's date of birth, the people to include services, including the child, and then the criteria. The criteria are that the child has to be experiencing an emergency. The family doesn't have sufficient resources to meet the need. The emergency that the child and family are experiencing, that would be the circumstances by which that brought them into the CPS assessment and required a substantiation or in need of services. You're identifying the list of services needed. You're identifying and acknowledging that checking off that the services can only be provided for up to 364 days. So you're going to put down what the last day of eligibility is. And remember, it's 364 days from the first time the child was eligible, when it was started. So you may have to go back and look at your intake if you coded R at intake. If, let's say, you weren't using 9 with 211, if you used R, then it would be back from then. If it's in 210, then you'd look back from there. Now, if you haven't used it for some reason, let's say you used one of the other codes, you used 210 CPS for that child for the entire time that they were in the assessment phase, then perhaps your 364 days would start the first day of in-home services. But it's critical to know and understand when that started. Again, that communication piece is absolutely hyper important here. And then down at the bottom, the services that are provided within the first 30 days of TEA eligibility have to be documented. It has to come under one of these broad headings. In-home services would include assessment, case management, and service planning and coordination, which is obviously critical. That's part of what we do in in-home services. So that service by itself is going to automatically meet that requirement. But if there are other services that are being provided, counseling and treatment, family support, those things can be listed as well. But your case management and service planning is always going to be your essential default here to assist you in completing this documentation form. As you can see, it's a one-page form. It's fairly simple, but again, the consequences of not doing it can be huge if you get pulled for an audit and you don't have this level of documentation to support the work you're doing. All right, so we'll go back into our slide presentation. We'll talk about 215.9. Again, very similar to what we've discussed in 210. It's federal funding. It's capped. Have to have a finding of substantiation or in need of services. Family has to have 200%, be at or below 200% of the federal poverty level. Child has to be living or have lived with a specified relative within the last 6 months prior to the episode. Child must be a U.S. citizen or qualified alien with appropriate documentation. And the verification form must be in the record, the MOE verification. Now, if the MOE verification is in the record from your 210 case, you can go ahead and utilize that verification. Remember that it has to be recertified annually. So if your services have been going on for over a year since the first time you verified MOE for that episode, then you would have to do a re-verification. Otherwise, just taking that form and utilizing it, placing it in the 215 record works to meet the eligibility requirements. 215.23. Again, same thing from 210. It's state funding. It's capped. We already talked about that it was provided to help pay for the state share of some staff expansions. The family's income has to be at 200% of the poverty level. Child has to be living with a specified relative, and eligibility must be documented in the record. Nothing new between this program code, the use of 23 with 215, and the use in 210. Now, IHE and CPS are very similar. Okay, we've already talked about CPS. Now we've got a new partner to join the party, which is IHE. It's state funding. There's no financial eligibility required. This can be an option for coding when the child is not eligible for 4E. As we mentioned, until the child is 4E eligible, you have to code to something alternatively to that. However, if the example I used before where the child came in early May, let's say you haven't met all of the requirements in the month the child came into care and you don't meet them until the following month, then you would have to use something other than Z for that entire month. And IHE or CPS could be candidates for that. That's an excellent way to spend down that money. However, again, you must be communicating with your business office or fiscal team to determine if the funds are available for your day sheets or if they are using them to pay for other services. Again, we don't want to overbill or overtax one particular pot of money because it'll run out. And if it runs out, then again, we aren't drawing anything down. It's like a worthless check. Now, 215X, oftentimes we talk about X marking the spot and what we look for. In this case, this is more like Family Feud. When you see the big X up on the screen, as in it wasn't a good answer. 215X, X is federal funding. It's capped. The child cannot be a candidate for foster care or at imminent risk for removal, which means they cannot qualify for Z. If you've met the qualifiers for Z, then they cannot use X. They are in direct opposition to one another. There is no financial eligibility. And the reason that I say that it's sort of the Family Feud X or X doesn't mark the spot is it's really the child welfare funding of last resort. And the reason for that is, as you've already seen, child welfare has a number of funding pots available to them, and we're not even through all of them yet. However, X is one of the only pots that certain other areas of agency services have available. For example, adult services. X is one of the only pots they have open to code to. And so, in general, counties tend to want to leave that pot for adult services and not necessarily have child welfare code to that when there are these other pots available. So if you're going to consider using X, it should only be in consultation with your business or fiscal team to determine that, yes, indeed, there are no other pots available with money in child welfare, and that your business office wants you to go ahead and take advantage of it. There are times they may tell you that strategically they prefer you to code to a different pot even if there's money not available, because they want the money to last longer for adult services. and it may send a message in your coding in child welfare of what areas you currently have needs in, where your population's needs are the strongest. So again, if you are going to ever consider using X in child welfare, it should be in consultation with your business office. And then there's N. No, like we talked about before. This is an all-county fund pot. There is no federal or state participation, and it must be used for all undocumented children. This is not a choice. If the child you are serving in 215 is undocumented, then you must use N for that code. Pardon me, I had to take a drink there. And by using N, that will draw down no other funding, but that is a requirement based on the undocumented status. Now we're going to move into 109, into the foster care side of the equation. So 109 is used for the primary elements of all the permanency planning, case management activities, again, as well as all paperwork and travel are included in the service code. So anything that you're doing essentially related to foster care and permanency planning fits under 109. The program codes that are allowed to be used are Z, P, R, 0, 9, V, X, and N. And again, you'll notice a few new codes have come into the party here, specifically P and V. Again, if the child is undocumented, then you must use program code N. That hasn't changed just because we've moved into foster care. Now, also, we're going to pair and talk about here, even though 009, Adoption Case Management, is a separate service code, the program codes that are associated with it, the requirements are the same. So we're going to talk about the definition of what adoption is here, but then when we talk about the program code partnerships, it'll be the same for 009 and 109. So 009 is for all children in DSS custody for whom the court-approved plan is adoption, or for whom both parents' rights have been terminated by TPR or voluntary relinquishment. That means if your child in your custody has had the plan changed to adoption, or that both parents' rights have been terminated by TPR or voluntary relinquishment, you should be opening 009. It doesn't mean that you automatically close 109. 109 can and should remain open while 009 is open. But 009 is for the specific case management related activities focused on the adoption side. So anything that that worker is doing, and you may have a situation where you have two workers assigned. You may have your foster care worker who's working 109 case management activities, and you may have an adoption worker working 009. That's absolutely fine. Some counties have one worker doing both. It depends on your county and the division of labor. However, if the child meets the adoption requirement as listed on this slide, then you should open 009 in conjunction with 109. The program codes that are allowed to be used, as I mentioned, are the same as 009, ZPR, 09, V, X, and N. And if the child is undocumented, you must again use program code N. Now, the first code we're going to talk about is the 109 and 009Z. This is 4E. As I mentioned in 215, this is federal funding and it's uncapped. It is determined by virtue of completing the 5120 or by the NC FAST system when a child enters into foster care. Eligibility determination includes evaluation of multiple variables, including the legal documentation of how they came into care, their living situation at the time of entry, the family income, and AFDC connectedness. Now, the eligibility also has to be redetermined every 12 months at least once via a 5120A or an NC FAST process every 12 months after the initial determination. Now, let's take a look for a second at the 5120. So when a child comes into care, you're going to go ahead and utilize the 5120. This document, which we will see in a second. Right now, you'll have to forgive me. Right now, I'm having some technical difficulties here, and I'm having trouble seeing it. But if you'll bear with me, we'll get that up there. But while we're trying to get that up, I will tell you what's on there. The 5120 focuses primarily on, the first thing is how the child came into care. Okay, and that's going to be usually by legal. You're talking about a court order. The majority of our children do come in via court order. So that would be the section of the 5120 that you would focus on filling out. The major areas you're going to focus on there are the contrary to the welfare and best interest, as well as reasonable efforts to prevent entry to care. Those dates are going to be documented in the 5120. And I apologize, I'm having trouble seeing it on my screen, so we may not be able to bring it up at this point. But if y'all can see it now, it may just be on my screen that we're having difficulty seeing. So I'm going to go through it and have hope that you all can see it as well. But in this form, the next thing that we're going to be focusing on is their removal home. So the removal home is the home at which the child is connected to. And there are 4 questions there. There's the, was the child living with the parent at time of removal? If they were, great. Then you stop and that's your removal home. If not, it's going to look to specified relative. And again, remember our definitions of specified relative. If indeed the child is connected to a specified relative and the petition talks about why they can't remain there, that would be your removal home. Otherwise, you have the final question, which focuses on, did the child live with a parent or any other specified relative within the last 6 months prior to removal? So if you determine removal home and it meets the requirements, you'd move through the budgeting process. As you scroll through the 5120, you're going to go through the sections that focus on AFDC connectedness. That's where we're going to look at the budget. Did the family meet the poverty levels that were required by the federal government for AFDC connectedness? It is important to take a moment just to remember that these poverty levels are the poverty levels from 1996 and have not been indexed for inflation, which means that if we say these families are meeting the poverty level, we're not even talking about the poverty level today in 2020 when this was recorded, but we're talking about a poverty level from almost 24 years ago. It can be pretty sobering when we think about that about 50% of the families that and children we take into care do meet AFDC connectedness, which means about 50% of our families are meeting a poverty level from 24 years ago. So when we go through all of these requirements, ultimately, if indeed the form tells us after filling it all out that we met all of these requirements, then we can determine that the child is 4E eligible. So then we would be able to start coding to 4E. And again, like the 215 scenario, if the child is eligible and one day of the month, they're eligible for the entire month. So if you end up meeting the requirement on the 30th of the month, but the child came into care on the first day of the month, then you would be able to claim the entire month. If not, then you would go, if it goes over to the next month, then you would be able to start from the first day of that next month. Now, as I mentioned, every 12 months, it's required to do a redetermination. So the redetermination form is the 5120A. Now the 5120A, which we're going to try and pull up here for you, the 5120A here is a little bit simpler. It focuses on just a few items. It no longer requires us to determine income or AFDC connectedness. That initial connectedness is established when the child comes into care, and we don't have to reestablish it during the episode. So you would focus on the legal responsibility. How did the child come into care? Now, CARS agreements don't really apply any longer. Almost all of the CARS agreements have been eliminated. So if the child came in via VPA, you would fulfill this part of the form. However, if they came in via court order, which is the majority of our children, we're going to go ahead and answer these questions. Now, you would answer the date of removal, which is the day you took custody, the date of entered care, and this is a federal definition, but it is important to this form. It's the earlier of 60 days after removal or adjudication, whichever came first. So it's sort of the Price is Right, closest without going over, which came first here. So if the child came into care on the 1st of January and they were adjudicated on April 1st, well, that's beyond 60 days. So you would count out 60 days from January 1st, and it is actual calendar days, not just 2 months. So you'd count out, and you would end up basically on March 2nd, because February only has 28 days, and that would be the date you would enter here. And then you'd answer the rest of the questions. And the critical issue here that you're trying to determine, we're not going to go into too much detail about this form now, that's a whole different training for 4E, but is ultimately once every 12 months you are required to have a finding towards the finding of reasonable efforts towards achieving a permanent plan. And that has to be found by a judge in a hearing, in any enforceable order, any hearing that's been had during the previous 12 months, that finding would meet the requirement and you would be able to have reestablished your eligibility for the child for 4E for the next 12 months. Excuse me again. And if you're in NC-FAST, while you wouldn't be using this form, the questions that NC-FAST is going to look at when you do a redetermination process are based on this form. So ultimately, you'd be documenting the same things, and NC-FAST can produce a 5120A for us for a printed version if we needed it for an audit. So we'll go back to the presentation now, but just remember that eligibility for 215, for 109 or 009Z is via the 5120 initially, and then every 12 months via the 5120A or their NC-FAST counterpoints. If the child is eligible for 4E reimbursement, this code must be used. Again, same thing for 215. It must be used. It is the trump of all of other codes. The child must be in a licensed placement in order to use 4EZ for service codes, unless the child is residing with a specified relative who is actively pursuing licensure. So that means if they're living, let's say you place them with a kinship, in a kinship placement with a grandparent, aunt, uncle, sibling, whomever. It must be real kin, not fictive kin, but real blood kin. If they are with a specified relative who are pursuing licensure at the time, not just considering licensure, but actively involved with the licensure process, then you can code 109Z to that day sheet while the parent, specified relative, whomever, is pursuing that licensure. However, you may not claim maintenance, that's a whole different issue, board rate, until the license is actively achieved. But otherwise, you can go ahead and code to it. And as I mentioned earlier, 4E can be coded from the first day of the month that all the requirements are met. And you can see again that example. Now, a new code, P for 109 and 009. It's federally funded. It is a capped pot of money. It is usually a relatively small pot of money. However, it can be very helpful. But it has to be used in very specific situations. It is either for children who have been in DSS custody less than 12 months, and this would again be for children who are not 4E eligible, because 4E would trump, or if they've been in DSS custody longer than 12 months, and this is important, this also must be in place, the plan is adoption or custody and guardianship with an identified relative or caretaker. That means the plan or concurrent plan may not be reunification, and it may not be APLA. If either of those two plans are in play, then the child cannot be coded to P. But if they're in care longer than 12 months and the plan is adoption or custody and guardianship, with an identified relative or caretaker. You must have them identified. It can't just be wishful thinking that we made the plan and we hope we find somebody someday. But if you've got someone identified, then you can use P. And there is no fiscal eligibility requirement, which is helpful to us. We don't have to worry about the child's fiscal eligibility. So you may be imagining to yourselves right now, there are some specific children in your caseload that this might qualify for. That's really what it's designed for. It's a very specific population to help either get these children permanency quickly, i.e. the children who are in care less than 12 months, or to help facilitate permanence for a child who's been in care for a longer period of time. Next is one of our old standbys, RN0. Again, federal funding, it's capped. Remember, it can only be used for a maximum of 364 days from the beginning of an episode. The episode is considered to have begun the first time R0 was coded. Remember that more than likely is going to point all the way back to 210. And fiscal eligibility is documented via the 5120 or an NC FAST, and you would elect the TEA section of that. You can fill that out when you fill out the 5120 or within NC FAST, and that would meet your eligibility requirement for that. Again, the most important thing not to get tripped up on is don't use it longer than 364 days, because that will create an audit exception for you and be an error requiring payback. Next, another old favorite, 9, federal funding, capped. Child has to be at 200% of the federal poverty level. The child has to be living in the home of a specified relative or in a licensed family foster home. So the child can either be in a relative's placement or in a licensed family foster home. The child has to be a U.S. citizen. The child must have been removed from the home of a parent or a specified relative, and eligibility in this case would be documented via the 5120 or an NC FAST. So you don't necessarily have to have an MOE form in your record, although some counties choose to do so just to make it simpler for themselves. That's absolutely fine. But the eligibility has to be documented every year, and the 5120 will meet that first eligibility requirement for you. Now there's another new player, V as in Victor. This is also federal funding. It's capped. The child must be at or below 200% of the federal poverty level, and fiscal eligibility for this is documented via the 5120 or an NC FAST. This is a fairly simple one to meet the eligibility requirements for. And it's a pot that is available for children who have been in care for longer periods of time and may not be 4E eligible. This is a pot that a lot of those children end up defaulting to. But again, you've got to make sure that you can justifiably show that the child has met the eligibility requirement. Generally speaking, if a child is receiving Medicaid in foster care, then they've met this 200% federal poverty level. However, you still need to make sure of that and have that level of documentation, and the 5120 or NC FAST help you to meet that. Now again, we have X. It's still a capped funding source. There's no fiscal eligibility, and as I mentioned earlier, it should only be used after consultation with your business office or fiscal team because it is a funding source of last resort. Child welfare should only be using this if their business office indicates that it's appropriate to do so. Please don't just choose it to use without that level of consultation. And then N, as in no. It's all county funds, no federal or state participation. It must be used for all undocumented children. That's the given time that we have to use it. However, there could be circumstances following a specific audit finding where a case would be in a penalty status where the N has to be used for that. That's only something that would be very case specific, and you'd be advised of that by the auditor or the monitor as part of your corrective action plan. So if it hasn't been brought up to you, you don't have to worry about it, and the only times you would use it other than this scenario would be for all undocumented children. So again, hopefully it's one we don't use that often. But if you do have an undocumented child that you've had to take custody of, then N would be the pot that you have to use. All right, now we move into a slightly different code, 010, for adoption services. Now this is also an adoptions code. However, this is not a code you should use for adoptions for children that are in DSS custody. Okay, this is a code that you would use primarily for adoption-related services. Private adoptions like a step-parent, a relative, or an independent adoption, which your agency may participate in. And if they do, that's excellent. It's a great way to help provide a service to the community. And you can use the following codes: P, V, X, or N. Now, the requirements are the same for 010 as they are for 009 for these codes. So I'm not going to go over them again directly. I'll refer you back to the previous slides if you wish to use those codes. However, if you're using a sliding scale, a fee scale with a family for these services, then you would have to use N. You're not allowed to draw down funding if you are getting paid for these services by this family as well. So if you're not claiming any funding from the family, then you could use PV or X. If you are claiming funding from the family, then you would have to use N. You cannot double dip, take payment from a family and payment from the system. Now we lead up to 990G. 990G is for leave time and tasks that cannot be associated to a specific child or client. Okay, so if it's anything that can be coded to a specific service, if you're doing anything actively related to the child's activities, if you're doing something related to 215 when the case is open for 215, if it's case management, travel, paperwork, anything like that, a case-specific conference, a staffing that is related to that child, a CFT, or if you're in 109, a permanency planning conference or anything of the like, that doesn't go under 990G. However, things that do are things like your annual and sick leave, comp time, training and travel time to training. If you're attending a training that is not child-specific, or a meeting that is not child-specific, an example today, the time you've spent listening to this web training, that's all going to be 990G time. So we would not be utilizing that with client-specific meetings, but your staff meetings, agency meetings, other community meetings that you might attend would be 990G. Now, what's important to notice is it's not an N, which means it's not all county funds. Back in the day, and again, I'm dating myself, but I was trained that 990G was the equivalent of N, all county funds. That's not actually the case. There is a formula by which that minutes that are coded to 990G actually do bring down some reimbursement based on other coding. But that's why it's so critical to get your other areas accurate, because the coding that you put to 990G, actually the reimbursement you get for that is dependent on how you've done your other coding. So we won't go into too much more detail about that. You can always reach out to your business staff, business team, or your local billing liaison if you have questions about that. So we've gone through quite a lot today. And your head may be spinning about some of this, and I understand that, but one of the reasons why we've recorded this is to allow you the opportunity to go back and review it at any time, but some basic steps and things to think about that will help make this process easier for you. One is to make sure you communicate. Communicate, communicate, communicate. The business office fiscal team and the services social work team should be meeting monthly, in our opinion, to help discuss your process. How are things going? What pots of money have money still in them? Where are you budget-wise? And so the business team can understand more about the population that the social work team is serving, and equally the social work team can understand more about where the business office is in terms of the pots of money that are available to you and help make sure that you're not making mistakes that can cost you or the county money. Reviewing your day sheets. Supervisors should be reviewing submitted day sheets weekly and signing off on them. Now, that doesn't mean that a supervisor should automatically know every child in their worker's caseload and what they're eligible for off the top of their head. That's beyond a normal level of expectations. However, a supervisor should be well educated enough about the process to certainly be able to identify outliers of codes that may not normally apply, that fit in the core that we've talked about, and then at a bare minimum be able to ask questions of the worker and go, all right, this is not normal. Doesn't mean that it's wrong, but let's make sure that we know, A, that the child's eligible for it, and B, why we're choosing to make this particular choice. Again, we want to focus on the KISS model. Keep it simple, social worker. If we don't have to make it harder on ourselves, why would we? And then educate. Workers and supervisors should be aware on a regular basis as to what the eligibility requirements are for each program code to help make correct selections. Now, to that end, we've created an eligibility at a glance worksheet, or a cheat sheet, which I'm going to try and pull up here for you now. And this cheat sheet, if you look across the top, and it's a two-paged, it's a two-sided sheet, but across the top it has the different program areas like R, V, 9, 0, P, all the different headings, and like Z up here has for Z with 215 and Z with 109. But it has then the requirements below it, the eligibilities, okay? And it talks about what needs to be in place. And if you'll notice here for R, it does say that there's no eligibility determination required for 211 and 210. And it says that verification of TEA, the bottom part here, TEA eligibility, or the 5120, meets that requirement, except for 210 and 211, because you don't need to. With V, it says that a copy of the Medicaid card or other income documentation helps meet that documentation requirement. And again, you can see that across all the areas that have been discussed, the different focuses that you need to have. And you'll see that 215 and 109 are slightly different for Z. Then we get down here, some of the other codes that we've talked about. 23 is here, IHE, CPS, CRF. Now, two that we haven't talked about today. One is MAC, and the reason we haven't talked about that is there is a whole separate training. There's a full day training as well as ongoing webinars that are available for MAC, which I highly, highly encourage counties to take advantage of. MAC is one of the only other uncapped pots of money we have available to us. It is only available in specific situations for clients, but it is critically important to make sure that your county is evaluating the opportunity to utilize MAC. And then 24 is a very specific subset of funding, and your regional child welfare consultant and your local billing liaison can talk to you about those codes if you haven't been spending those and if you have questions about it. But this eligibility at a glance worksheet is available to you to download, and there's a link to that. Believe it'll be when you actually first come into the room or select this training, it will make it available to you. And you can get it also from your regional child welfare consultant. They have copies of this, or you can reach out to me or any other member of the eligibility team. The 4E eligibility team for the state can make this available to you. But this is a great cheat sheet for all workers and supervisors to have. Again, it's not all-encompassing, but it helps give you the highlights of what are required for each of the major core child welfare program codes. So in going back to our presentation, like I've said, it's critical that you do communicate, that you review your areas, and that you educate yourself. And in terms of education, there are two resources that are really helpful. One is the CIS manual. This has definitions of all of the service codes. Remember, I said there are thousands of different combinations. Well, this subset of the manual, the appendix, actually lists all the different service codes and ultimately all the program codes that they can link up with. There's a great chart there that you can see. If you're curious about going further, or you're curious or something falls into that maybe 15 to 20% of cases that don't fit the actual core service codes, the SIS manual can give you those definitions and the program codes they're associated with. And further, if you're interested in exploring more about the actual funding manual and their requirements, the manual appendices 3.1 through 3.7, which the link is to below that, that will tell you more about the specific funding areas that are available and all of the very specific requirements that they have. That being said, I very much appreciate you having taken the time to join me for this webinar. I hope that it's helped to provide some illumination to you on some of the basics around daysheet coding, and ultimately helping you get credit for the very important and challenging work that you do. The work that you do is critical for the welfare and the betterment of children and families in the state of North Carolina. And I and every other member of the state staff appreciate all of the hard work that you do and the time that you spend to take care of those children and families, and ultimately, hopefully, of yourself as well. With that, I wish you peace and a good rest of your day. Thank you again for your time and attention.